This is Dr. David Shine, and welcome to Business Law 101. Note that the word merchantability must be there. Now, it says it may be oral. That is a very dicey situation because that also invites someone to claim that they did not get the waiver warranty. So think about that. For most of us good business people, we're going to make sure that the disclaimers of these two implied warranties are definitely included in the warranty package. And so it's something that's very important. Now, at the bottom of the slide, I would have started a separate slide, is Magnuson-Moss Warranty Act. This, folks, is also known as the anti-lemon law, and it goes back to a particular period in the United States regarding environmental protection of all things. In 1970, President Richard Nixon signed the Environmental Protection Act. We had a situation where we had a lot of pollution in the United States, a lot of bodies of water, including right here in downtown Houston. Buffalo Bayou was so badly polluted, there was no wildlife in Buffalo Bayou. And there were a lot of other problems. In Los Angeles, they invented a term called smog, because they had smoke from cars and manufacturing and fog coming in off the ocean. The prevailing winds come in from the Pacific Ocean and come easterly through the city of San Francisco. There are mountains behind the city, and it would stop the air right there, and it would trap this bad envelope of air around the city of Los Angeles. And so the city was quite famous for bad air. Denver, Colorado, Pittsburgh, Pennsylvania, other cities that were very well known for having very poor air quality. And again, most American rivers were heavily polluted. In our nation's capital, the river that runs up to the Turning Basin is from the Chesapeake Bay, was famously very, very polluted. It ran around the Jefferson Monument and National Airport in Washington, D.C. So there are a lot of different places that had significant pollution. In any event, one of the number one contributors to pollution is the automobile. And so around 1972-73, the American manufacturers, Ford, Chevy, and Chrysler, began to experiment with ways to make the cars be less polluting. And these cars were some of the worst cars ever made in the United States. And in fact, it gave a gigantic boost to the major Japanese automakers, particularly Toyota, Honda, Mazda, and at that time Datsun, now Nissan. And so people began to turn to those cars because they were better made, and they already were designed to be energy efficient, didn't need as much pollution control as the larger, heavier American cars. So in any event, because these cars performed so badly, people went to their Congress representatives and said, hey, car is a major investment for most American families, and this is really a bad deal for us. And so to make it clear that the Congress was involved or interested in the problem, they passed Magnuson-Moss, and basically it says, if an automobile is repaired 4 times for the same problem, a new automobile, then it can be brought back to the manufacturer. So it's a pretty interesting deal, but I thought you might find it interesting to know how that came about in the United States. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.